Hello and welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss a very, very important issue that concerns our Chief Justice of India. On November 9th, 2022, he took oath as the 50th Chief Justice of India. That time, we had run a series called Hope. There was a lot of hope amongst a lot of people in the legal fraternity outside, in the business community, about Justice Chandrachud taking over as the Chief Justice of India. And after he's completed 150 days as the Chief Justice of India, we do one more show where we, of course, are going to discuss about the very important decisions that he's taken, the judgments he's delivered. And of course, there is a lot to discuss. So many things have happened. We also have a vocal Chief Justice who speaks his mind. So there is a lot to discuss on that side as well. And I have a very eminent panel to do that with me today. I want to welcome Dr. Abhishek Singhvi. As you all know, he is an eminent jurist, senior advocate. He's also served as ASG, and he's one of the few lawyers who I would know as the third time sitting member of parliament. He also has headed the Parliamentary Standing Committee on Home Affairs, and currently is also heading the Parliamentary Standing Committee on Commerce. The interesting insight here is he also gives us a lawmaker's perspective, in addition to being one of the foremost lawyers on the commercial side and the constitution side at the Supreme Court of India. Good to see you, sir, and looking forward to some very interesting insights. I have with me Mahesh Agarwal. He's a managing partner of Agarwal Law Associates, one of India's leading law firms at the Supreme Court of India. Any big matter, and you would sure to have seen Mahesh Agarwal's name on it. Good to see you, Mr. Agarwal, and looking forward to some insights from you. I have with me Mohit Saraf, managing partner of Saraf and Partners, a full-service law firm, and one of India's fastest growing, with over 203 people, if I'm not wrong, at last count now. He's, I think, in the past year given employment to lawyers more than any other firm. That's why he also remains in news. He gets us viewpoint from corporate India. Also on the commercial side, a very fine mind. Recently was if I'm not wrong, at the Bhopal Judicial Academy, training judges on contracts, also on commercial contracts. We would want your inputs on the commercial side, what the business world thinks about how things are going in the Supreme Court, the kind of judgments that are being delivered. Thank you so much for joining. And at the outset, may I request Dr. Abhishek Singhvi that in the first 2-3 minutes, if you could lay the ground first about 150 days of Justice Chandrachud, which I may qualify was a schoolmate of yours at St. Columba's.
I think to be as fair and objective as possible, it is been almost frighteningly active, this Chief Justice. And you really need this time you are giving us, Tarun, to analyze him on different facets. On the facet, for example, of judgment writing. It's amazing when you get into the details, the quantum, not merely numbers, the quality, the nature of those judgments, the diverse subject spanning. So that's clearly one head. His judicial work, which is the primary reason he's there, has been outstanding. The second head I'd like to comment on as we go along in the program is the innovative approach on so many facets. And this innovation and innovative approach is, I am talking more on the managerial, the non-judicial side. There is, of course, judicial innovation in his judgments, but I'm now talking of the managerial, administrative, non-judicial side. Third, what has he reflected as his philosophy, both as a human being, a person, and as the Chief Justice of India? And fourth, I think he brings to it a quality of writing, a quality of thought process, a quality of expression, a quality of putting it, which is quite remarkable. So I think these 4-5 aspects, as we discuss in more detail, will show that these short, 5-6 months have been frighteningly active. And I use the word frighteningly in a positive sense, because to keep up this pace for the rest of the tenure of 2 years will itself be a challenging task.
May I request you to first start your first comment on the judicial side before I move to Mr. Mahesh Agarwal, your first comment?
Well, when you told me about this program, I checked up. He's been there for around 6.5 years, not as Chief Justice, but as a judge, apart from being an Allahabad chief and the Bombay chief. As the judge in the Supreme Court, he has already authored something like 513 judgments. But look at the range. Privacy judgment to be a relatively junior judge and to write for 9 judges for the court, as they put it. Remember, this Puttaswamy, so-called, was also the judgment where he overruled something which we've been writing for many decades, saying that it should remain unoverruled, non-overruled, only as a stark reminder of how wrong the Supreme Court can be. You know, like the Dred Scott decision in USA or the Liversidge and Anderson in UK. But he wrote for 9 judges. And that itself is, for a relatively junior judge, a great achievement. He has written about how the Kerala High Court was wrong when they annulled the marriage of a girl who had converted. He has done a major concurrence in the Joseph Shine judgment, the so-called adultery judgment. By the way, in both privacy and adultery, he has overruled his father, Justice Y.V. Chandrachud, for whom I had the privilege of appearing. The NCT judgment, which is a major interplay of balance of powers between the NCT governor and the NCT chief minister. And a sequel is in the offing, which I've had the pleasure of just arguing before him hardly a few months ago, and is reserved. That's a sequel to that. And so many more. I mean, I don't want to give you a list. Sabarimala, it was a concurrence. I had the privilege of arguing that. We lost 4-1. And then we have a review in our favor by a subsequent bench. And now the matter is at large open. Very important. Of course, decriminalization of homosexuality, the Navtej Sarna case. A very important recent judgment, which is gone and which is important for people like Mohit Saraf, but otherwise it's gone relatively unnoticed. The federal aspects of why the GST Council is not binding. He has given it weight, but he said it's not binding purely on federalism, which is a very interesting intersection of constitutional law and commercial law. How married or unmarried status does not create or disentitle you from your entitlement to abortion. So, he's shown this progressive spirit, his constitutional acumen, his civil court, he's done criminal matters also. I think there's a whole list of those judgments. And I think a judge's first job, more than anything else, innovation, managerial, speaking off the bench, first is judgments. And on that, I would give him very high, above 8 or 9 out of 10.
Thank you for explaining the parts on judicial work so beautifully, along with the judgments, many of which you spelled out yourself. I'll go across to Mr. Mahesh Agarwal, Managing Partner of Agarwal Law Associates. Mr. Agarwal, you're in the Supreme Court every day of your life, in some of the most complex commercial matters that I have seen. You get to observe him day in, day out. Your observations on Justice Chandrachud's 150 days as Chief Justice of India.
The first thing I would say that his zeal to work is amazing. 9th November, he took over as the Chief Justice. 10th November, one day later, he came out with a circular for automated listing that if you file matters on 1, 2, 3 days, Monday, Tuesday, Wednesday, they'll be listed in the following week. So the listing in the last 2 years was a major problem. So listing of fresh matters in one circular was completely streamlined. So it's one day of his acting as a Chief Justice that this happened. Then his zeal to work and encourage juniors. He is giving very, very patient, very soft hearing to all lawyers who are appearing, not just to seniors. So that encourages the entire bar. The Chief Justice is the person who leads the way for the bar to grow, and Supreme Court is very important for that. You will never find him lose his temper, get impatient. No person will leave his court feeling that I have not been heard. Had I been given a minute, have I been given 2 minutes or anything like that? You see, our basic problem in the court is that we have to make out a case in 60 days, 60 seconds. With him, that's not a problem. He gives a patient hearing, justice is done. Third thing, what Dr. Singhvi said, that on the judicial side, all his judgments are basically founded on true justice. What are the principles? Natural justice. Founding principle of any constitution is natural justice. Then privacy. Balance of power between the state and the center. Civil liberties and personal liberties, say in bail matters, he's been very liberal and he's been giving good guidance. In arbitration, as is spoken outside, he's promoting arbitrations, reducing interference with arbitration work. So, so in most subjects, his judgments are founded on true principles of justice. So I think we are doing very well. And one important thing which has happened is that there was some kind of an absence of permission to mention matters. There are myriad reasons for which we need to mention matters. It's for early listing, preponing, postponing, filing, some urgency, some bail, whatever it is. You will not imagine that every day he has over 100 mentionings. Mentionings start at 10:30. They go until 11:15. He doesn't lose his patience a bit. And I don't understand how it works. It's some magic. The system is that by 10:25, you have to give a slip of matter which has to be mentioned. Mentioning starts within 5 minutes at 10:30. And as you see the order of mentioning, every matter, he knows what is to be done. He knows the background and he passes effective orders. For example, list on so-and-so date, mention before so-and-so, this can happen, this can't happen, and very patiently and very smooth. So that has changed the spectrum and kind of ease for all lawyers to work in the Supreme Court.
Thank you for giving us the practical side of how court functioning has changed. I'll now go to Mohit Saraf, Managing Partner of Saraf and Partners. Your opening comment. You do work on the litigation side in your law firm, a lot of work on the corporate side, and you deal a lot with corporate India that way. Your opening comment on 150 days of Justice Chandrachud.
If you actually look at the 150 days, really, I think there are two things which comes out very clearly. One is on the personal liberty side and that principle of natural justice, and I'll talk a little bit about that. And the other part, which is actually very important, is that he's very realistic and yet reformist. I think that's the most important part. Like if you see, collegium system was criticized as an opaque. He said it's not the best. It can certainly be improved, but it is on the current situation, it is the best because it protects constitution. It actually it talks about supremacy of constitution over the other forms of the government, and it talks about basically that this entire thing settles the conflict between the judiciary and the executive, and that's a very important part. So he says it can be improved, but in the present scenario, this is the best we can get, and it helps you to protect the basic structure. On the pendency issue, which was again criticized a lot, he was very realistic. He said, yes, there are 5 court cases which are pending. But he also brought a very interesting point that till today, everybody believes that judiciary is where you will get the nyaya. And therefore, people actually resort to judiciary. And he again talks about that there's a lot of requirement to reform and innovate both on the judicial side and non-judicial side, so that the judiciary is able to be more service-oriented. I would say that's a very important part he's brought in. On the personal liberty side, I think last year budget, also the government came out with certain policies which showed that, okay, the government respect business community. Here again, particularly on classification of businesses and accounts as fraudulent account, he's brought the principle of natural justice, which is very, very positive for the business community. I think the other important point I would talk about is really the Election Commission judgment. This is, again, though he was not directly involved, but I think it sets the cornerstone of free, fair election, which is, again, a basic structure of constitution. And the way he's tried to do that is try to build up the leader of opposition, the prime minister, and the chief justice to appoint all future appointees. Will absolutely go a long way to deliver fairly and fairly. So these are very, very positive things which he has done in a very short time. And I would say clearly he's fearless and he's always on move and very innovative and trying to look at issues, acknowledge issues, and fix issues.
Thank you. Thank you. I'll take this issue to Dr. Abhishek Singhvi. I would like you to reflect on one thing. The Chief Justice of India on one side is the Chief Justice of India. On the second side, he is the Chief Executive Officer of the Supreme Court of India. He is the CEO He runs the Supreme Court as a CEO. Any decision, be it IT upgradation or anything, is in his hand. So there is a managerial function also. Would you reflect on that, the managerial side or the CEO side, as CEO Justice Chandrachud?
I think that's a very important aspect. I make bold to say, and I don't want to have any hyperbole or exaggeration, but I cannot think of any Chief Justice of India, and I've spent a lifetime in the Supreme Court, who has been a greater or better Chief Executive Officer purely for innovation and technology. Now, you forget that he's a judge writer, he's a judgment writer, he's a judge. For a minute, forget that. With all the heavy load of writing and 513 judgments already, with about just under 2 years still to go, or 1.5 years to go, you can imagine where he will reach by the end of 24. But look at innovation, look at technology. And that comes from his forward-looking, liberal, progressive approach, which is both pro-technology, pro-personal liberty, and clearly forward-looking. Some of the examples, perhaps even you may not remember, Tarun. For example, he has, with this nice little sentence about how our buildings, our court buildings, reflect a colonial British attitude. He has appointed a judge of the Supreme Court to do what is known as the accessibility audit for the disabled. Justice Ravindra Bhatt heads a committee to look at accessibility audit for how disabled can access our courts. Remember, of course, my criticism of this is that it is all Supreme Court centered. But I have no doubt that the Chief Justice of India will expand these fantastic ideas beyond the Supreme Court once he gets them entrenched in the Supreme Court. Because it is in India, we need many Indias in one syndrome to be changed. You have an India at the Supreme Court and you have a different India in the district courts. And that must change. Number two, already 34,000 judgments of the Supreme Court, which is the totality of all judgments since 1950, stand digitized. Roughly 3,000 of those 34,000 have already been translated not only into Hindi, but in regional languages. And that process in about 2 or 3 years will cover all the 34,000. Can you imagine? All judgments will be available in Hindi and other regional languages right up to 34,000. By next year, it will be 35,000. Then look at the transparency about collegium. You see, two things. I can't say whether a judge I'm appointing is good, bad, or indifferent. That should not be done. It should not compromise. But look at the extent he has pushed the envelope. He has first made it clear that I've written an article on this long ago. I said, when we sit, should have common criteria for evaluating someone. Well, he has described those common criteria in the collegium as we peruse the judgments, the number of judgments. We see merit, we then see seniority, we then see inclusivity, we see gender, we see geographical dispersal. But more than that, he has stated them in the appointments. So when a list comes appointing Singhvi, Agarwal, or Saraf, it gives a broad idea of these criteria without being specific. And since it's a positive list about the appointment, not why I'm rejecting, it doesn't have to be derogatory. Now, this is an advance. To some extent, this is an advance of transparency. A hackathon for new ideas. I was very impressed. They're having hackathons for new ideas for the Supreme Court. How many, I forget, I've been part of most of them for the last 6 months. 43 sittings for live streaming of constitution benches. 43 live streaming of constitution benches, including in the last 2 matters I've done, live texting, that simultaneous texting, and so on and so forth. I mean, basically, even opening the courts. One of the figures I read was that the VC system has been upgraded, and he's been pushing even high courts and tribunals which don't do it. Because of that, in the Supreme Court, you have 2.5 lakh attendees in VCs till a few weeks ago. So on and so forth. I think Justice Narasimha is head of a committee which should have been set up long ago on categorization. When Mahesh files a matter, the categorization at the moment can be A, B, or C. That leads to, subjectivity. So that is being now organized. So I think there are lots and lots of good things, and nobody has even looked at these things to the same extent, the same degree, and pushing both in momentum, direction, quantum, everything. But again, one sentence, this has to be expanded after a few months to our high courts. We are one India. We cannot leave the high courts behind, and to the district courts even more. That's where I think some amount of special effort will be needed by the Chief Justice. It's not enough to do it in the Supreme Court.
Very interestingly, the point when you pointed out translation of 3,000 judgments in various languages, Justice Chandrachud then emerges as somebody who's democratized law, because in India, law is Roman words and English, which a lot of Indians don't necessarily know how to speak well or read well. And by translation, I think you want to make a comment before I went to.
No, I'm not really taking a time, but apart from Justice Narasimha for categorization, Justice Bhatt for accessibility audit, I forgot to mention he has made Justice Oka head of an artificial intelligence committee.
Oh,
both for artificial intelligence and making the court paperless.
okay.
These are great initiatives. They don't have to be scoffed at or being cynical about, because it takes time, but it brings in a culture.
So, Tarun, if I can maybe make a point here at what
Yes.
Dr. Singhvi said, I think what he has shown, particularly on the non-judicial part, is huge. And I think he's going to have a huge impact. But remember, lawyers have and judges have a very limited time. When you have a very technology-savvy Chief Justice, what is really the requirement of time is, as what Dr. Singhvi said, that you need to translate it across every court in India. Therefore, what is required is to have somebody like a chief operating officer of the court, which can make sure that everything which is bringing it out, it gets translated quickly at the Supreme Court and then get translated across courts. Because I think somebody on a technology side or a operating side needs to be done. Because if Justice Chandrachud is going to oversee all these things, then it will be a big problem. And again, the translation will not happen across country. So therefore, I think this is a great opportunity to bring somebody who works directly under Chief Justice eyes and ear and translates his dream into reality across country.
Basically, a professional manager who can implement the vision of the Chief Justice of India is what you're saying. So his vision, his ideas, he can point well taken. I'll go to Mahesh Agarwal from Agarwal Law Associates for his comment on Justice Chandrachud.
See, I would say what you just said, that Chief Justice is not just a Chief Justice, but a CEO. A Chief Executive Officer is running the entire court and running the entire establishment. And the success of the running can be seen on the ground as to what are the actual things which have happened. It is not conjecture, but really things on the ground which have happened. Today, the disposal of matters is more than filing. So in 6 months, say 15,000 cases were filed, 17,000 are disposed of. So that's a big success for a court which is buried with pendency, that our disposal has become higher than the filing. Second thing, on the ground, you would see that vacancies are almost nil, as of now, at least in the Supreme Court. And effective steps are being taken for filling up the vacancies all over the court. Now, filling up the vacancy not just requires, it requires a lot of time, but important thing is all the brother judges have to be carried forward. So it shows teamwork. It shows that he is carrying on with his brother judges very well, that names are being suggested with such speed that there's almost nil vacancy. Now in Supreme Court, we'll of course see many retirements now and new appointments have to take place. But you can see it on the ground with regard to judicial appointments. Third, actual thing you can see on the ground is paperless. He is encouraging all filings to be completely paperless. It reduces space, reduces bulk. Our leader of the bar, Mr. Sibbal, has argued a constitution bench matter on an iPad. Even yesterday, he encouraged some people that why don't you come with iPad instead of 10 volumes. So he's encouraging lawyers who have been practicing for so many years to go paperless. So that's also a difference on the ground. All the courts in India have spent crores of rupees on setting up the hybrid system, the VC system. Many judges feel, though, now that COVID is over, let's go back to physical. But Justice Chandrachud has continued the hybrid system now, is encouraging other courts also to do that. Even now, a person in Kerala to Kanyakumari to Kashmir can appear on a hybrid mode before the court, and he will get as patient a hearing as a person appearing physically. So that's a difference on the ground, that even after COVID is over, things are normalized, hybrid system is going on, and VC system is being encouraged. Next point, that it's after many, many years that we are seeing that constitution benches are sitting regularly. Important matters are being heard. In last 6 months, so many CBs have sat. Now, what happens is that if a constitution bench judgment comes, it settles the law, and that in turn reduces pendency, because many matters all over India are waiting for laying down of the law by the court. So in effect, on the ground, you can see constitution benches functioning efficiently, judgments are coming, and the law is getting settled. What Dr. Singhvi said, that all judgments have been put online. Judgments have been put online, that gives free access to the public. Anybody in India has now free, open access to all Supreme Court judgments and their authentic copies. So there is no risk of any spurious website reporting something. You have an authentic Supreme Court website giving judgments that helps all students of law, people who are otherwise interested, educationists, everybody. So that's a big change. What I mean is that the CEO has worked so effectively last 50 days, then you can see the change.
Okay. Point very well taken. Thanks for sharing those insights. I think that judgment also helps a lot of lawyers who don't do so well in Mufassil areas where, they can't afford memberships of these judgment providing websites. That's also a good thing. So it's free for all. I'll go to Dr. Singhvi. Chief Justice of India is also what you called the ideas man. Primarily also because he's got the authority and the responsibility to implement the ideas, being a chief, like as Justice Chandrachud said, that he's not a Chief Justice of Tilak Mark, he's the Chief Justice of India. And the Chief Justice of India, when he implements an idea, has a far-reaching impact. Different times require a different kind of an attitude. I remember a retired Chief Justice of India who served in the 90s once told me how he set up one of India's leading law schools, which is now one of India's leading law schools. Justice Chandrachud, of course, digitization of courts. He has so many things on his plate. Could you reflect on this part of Justice Chandrachud, the innovations, the ideas man that he is?
Well, Tarun, actually, all the things you just talked about are about him being an ideas man as far as that is concerned. This is all about innovation, accessibility audit, new categorizations, artificial intelligence, really pushing the envelope, not in his court, but elsewhere, for VC, for hybrid, making these judgments available, putting a team together to take the next 3 years to translate all the 30,000.
In fact,
more than that, I think he is trying to lay down a culture of leadership where, let's not forget, after all, judges first and the legal profession second are and have been traditionally hidebound in tradition, in old rules. They are not easily open to change. They are resistant to change. This is a profession which is resistant to change generally. So he has brought in fresh winds to say that, look, let us not look at with suspicion at new winds blowing. Let us open the windows and the doors and allow new things to come. I have no doubt that he has up his sleeve many more such new things where technology and innovation will intersect. I think it comes from a certain mindset, and that is what is important. Now, this percolates down.
If I may interject at this point, you said one very interesting thing in your previous answer. These committees which he's formed with various judges, do you think he's providing a sense of leadership and vision to the court? And can you reflect on that aspect?
I have opined many times, and I think it's probably happening in a slow way now. But see, I have opined many times that barring the late 70s and early 80s, most chief justices after the mid 80s have had short tenures. 2 years is a relatively long tenure for this chief justice, relatively long. Most have had less than that, half of that, etc. Unfortunately, our system is heavily over-centric with the existing incumbent chief justice. Whether you call it politics, whether you call it distrust, whether you call it a hesitation, whether you call it anything or a diminution of power, there is not this concept of a handing over the baton. I've spoken about this earlier and I'd like to repeat it in your program. If you were to look down from now, we have chief justices known till at least 20, 30 or 32. There has to be a handing over of the baton. There has to be a collegiality and a collegium which is apart from the judicial appointments collegium, which I'm talking about. That collegiality and collegium has to be about deciding for a 5-year plan, if not a 10-year plan. I think 10-year plan is too ambitious. but a 5-year plan, not like our government 5-year plans, but a judicial 5-year plan, where a baton is handed down successively to the next 5 Chief Justices. We have now 5 or 6 in the offing. Now, that is something which has to be organized. That is something which has to be thought about. That is something where, you and I will never agree on everything. The 5 people on this panel or the 4 people on the panel will not agree. But we can agree to disagree on those issues and yet decide that we agree on a common minimum program for the next 10 years. I have used the analogy of political, common minimum program for at least 7-8 years. That will do wonders for the profession. Today, if I decide to start artificial intelligence, I know that I'm retiring in 2024, but the next man down the line will carry it forward. Now, there are enough such matters where consensus can be generated. There are, of course, enough matters where there is disagreement. By all means, keep them aside. But on matters where you can have, and we are lucky to have so many youngsters, if I may use the phrase with great respect, on the bench who will be Chief Justices. They are relative youngsters. So they will be able to carry that baton. And I think this will be the greatest achievement of people if Chief Justice Chandrachud decides to have this thing down. One more word of caution. A lot of the things we are talking about has a constitutional limitation, which we tend to forget. He's doing a lot of good things, all this innovation we've talked about and the others we've talked about. The limitation is that technically, it is completely technical, the Constitution does not give any power judicially or formally to a Chief Justice of India to control the administrative apparatus of high courts or courts subordinate to the High Court. You'll be surprised the entire subordinate court apparatus is controlled by the High Court. And the Supreme Court has no administrative power over the High Court. None. Zero. There are judgments which say that technically if the Chief Justice of India, I direct the Chief Justice of Delhi High Court, Mr. Mahesh Agarwal, to do ABC on the administrative side, it can be ignored. Now, therefore, you have to lead by example. Therefore, you have to lead by not making it technical or imposition-based, but on coming out from inside. And that's how alone you can enthuse, by making an example, pushing them, and people listen right down to the bottom.
I will like to bring this up with Mr. Mohit Saraf. There's a very fine judgment by Justice Chandrachud on the fraud circular, which incidentally Dr. Singhvi appeared in that matter, and he's in a sense said that promoters should get a hearing before their accounts are declared as fraud. Businesses look forward to judgments which in a sense, make doing business in the country easier. Sometimes there are excesses on the policy side. There are excesses, they are sometimes an overreaction to an incident. It happens in the bureaucracy. Sometimes you have to show your acting. But the courts, bring these things back to a certain level where, these things can be looked at from the perspective of sometimes policy excesses need to be set right by the courts, and courts do a fine job in this country of doing that. It would be a very, very worrisome situation if the courts completely stopped. And in fact, Dr. Singhvi was kind enough, he recorded a show on this topic, I think last week. But I would want you to reflect on this issue about how on the policy side, how the court's intervention is important, and Justice Chandrachud is also leading wherever it is required.
I think you're absolutely right. I think the clear thing, what the judgment talks about is that we respect business. If the business is doing unethical practice, they should be given a patient hearing. It should be a reasoned order. And if they have to be classified as fraudulent, so be it. But it should not be non-speaking order behind the closed door, because that does not build transparency and does not bring rule of law. I think that's a very clear thing. Same thing, if you think about it, that all these years, the business community in India have been very, very worried about IBC, criminal law. At FICCI, I'm on the national executive. We work very closely with government on removing criminal liabilities on businesses and directors. Now, again, here also, if you see the Chief Justice making it compulsory for every bench to hear 10 bail matter every day. What it is also doing it by leading by example, that he's giving bails, he's looking into the case, and also removing that nervousness at lower judiciary. That if you give a bail, that means somebody will think that there is some hanky-panky going on. So I would say that's because he's giving personal liberty, he's giving the personal liberty importance, he's appreciating that, and he wants to control. He does not want everybody to have a field day, but he does not want to just put people behind the bars without really the due process and without the requirement. And bail is the rule, not the exception. So I would say all these things is building a lot of support. Today, I think at some stage, the business community, the business houses were very, very nervous. But today, I think even if you look at the Adani case, after the committee was set up, I think that generally the markets and the industry gave a thumbs up, because they believe that judiciary will not let anything go under the carpet, but also will make sure will not destroy just because if something is political. So I would say that is a very, very strong sense. And again, as Dr. Singhvi said, that this is leading by example. You are taking bold steps, bold judgments, and also empowering the lower judiciary to take this thing forward. So I think it's a very, very positive step.
Point well taken. I'll take this now to Mahesh Agarwal, Managing Partner of Agarwal Law Associates. Mr. Agarwal, your presence in some of the most hotly contested corporate battles or commercial matters in Supreme Court is a day-to-day occurrence. When such judgments like one on the fraud circular or some others also which is delivered, what kind of message does it send across the judiciary? Because the court is taking a stand where business is hurting. And in India, it is not uncommon for, there is a decision where policy excesses do happen. I think Dr. Singhvi will reflect in his answer on that because he's also in parliament. So, he can also give us that perspective. But I want to know from you, how is it on the commercial side? How the court is looking on the commercial side?
See, sometimes the government policies and procedures can be extreme and harsh. And it is happening in many situations where the business is not getting even hand at the executive. The only remedy, the only solution for the business is to go to court and look to court for justice.
Yes.
Now, this judgment and many others have given a lot of confidence to the business that they are getting an even hearing, they are getting a fair hearing, and the courts are upholding rights of all businessmen and especially the promoters. What had happened in the circular, as you are aware, was that without a hearing, a person is declared a fraud, which has severe consequences. One way to look at it is, once the bank has declared somebody a fraud, you must be a fraud. You have to face the consequences. But the court has read into it some rights of the promoter that at least give a fair hearing, some natural justice. So the business today is looking at the courts with a lot of confidence and a lot of faith and being treated fairly. Now, this judgment and others by the Supreme Court are paving the way for the other courts in India, the high courts or the lower courts, to be also fair and not be completely pro-government, pro-revenue, pro-investigating agencies, but be more balanced and support businesses. So I think it is very critical for the business in India to grow as well as it is. Employment has to grow. Many issues have to be taken care of. So the path which the Supreme Court has laid down, I think, is very progressive.
Yeah, so as Mr. Mahesh Agarwal says, a progressive path laid down by the court and the Chief Justice of India, Justice Chandrachud. I'll take this to Dr. Abhishek Singhvi. So very interestingly, if you see, the kind of judgments that are coming out of the court instills not only confidence in the business community on the bail side, what Mr. Mohit Saraf raised on this fraud circular judgment, it shows that, there's a pro-business India. And the courts are there. There might be excesses in one or two instances, but the court will set it right. Your observations on that over the past 150 days that he's been.
I had the privilege of being the lead counsel in the fraud circular case, on which we are talking a lot. And of course, we've had a separate program recorded on that, so I won't take time on that. But, it was interesting. The main argument of a body as important and powerful as the RBI, which opposed me, was, and there's, something which took a lot of time. It was argued when he was in court too. He was not the Chief Justice. And it was argued for almost 4 or 5 different days. And the RBI said, look, what is this fraud circular? The principal job involved here is that I will refer Mr. XYZ to the CBI or to the ED as being a fraud. So the argument was, interestingly, and which is well established in law, that before I refer you to be filing an FIR, which the CBI may do or the ED may do, I don't need to give you natural justice. Surely I don't have to tell you that, look, I'm about to file an FIR against you. It's established in law. One of the arguments I made was that, look, this may be called fraud, but the well-established law is that where either the statute specifically ousts or excludes natural justice, you may decide that to exclude. Where it includes, the issue doesn't arise, you have to include. The real issue is where it is silent. Where it is silent, you will read into, and the rightful phrase in the old law, the common law will supply the omission of the statute. So you read into it natural justice. And that's what Justice Chandrachud did. So he dealt with something which was full of prejudice, showing that prejudice cannot take the place of reasoned judgments. The whole case involved examples where fraud of 1,000 crores, 2,000 crores was bandied about by RBI, by the counsel who opposed. That's one. Second, in this discussion on the RBI fraud case, we tend to forget another natural justice judgment which has come a few days ago. Sealed cover fate has been sealed. But the sealed cover fate which has been sealed by Justice Chandrachud's judgment a few days ago also involved natural justice, because sealed cover is nothing but a denial of natural justice. Sealed cover is another way of denying natural justice. There again, he has spoken very strongly, and that's the national security angle. He has said that even national security, merely the mantra that, Saraf says in Singhvi's case, that it is national security, that mantra will not help him. He has to demonstrate that this requires a exclusion of natural justice. And Singhvi in turn can demonstrate that there is no national security angle except a mantra which is being recited. So that is another great advance. These are the incremental ways in which Indian law advances. And I'm so happy that the sealed cover procedure has been sealed.
Point well taken. Now we'll move to a round of closing comments where Mr. Mohit Saraf, Mahesh Agarwal, and then Dr. Singhvi can also speak on the judge and the person. So we will start with Mr. Mohit Saraf.
I would say, if you look at from the corporate India perspective, litigation in India is a very long drawn process. It is a stated fact, and that it almost takes 1,445 days for a matter to get resolved at the first instance in India, which is over 4 years, compared to 145 days in Singapore. Now, what it does is that if you are investing into India, your hurdle rate of capital is much higher. And because of that, everything, the power, the road, the port, everything becomes expensive, and it affects the competitiveness of the country. I think this is what everybody's saying, that the pendency has to be resolved very quickly. But if you look at today, everybody is only talking about supply side, disposal of the case. They are talking about you need more judges, the population to judge ratio is low, the productivity is low, the case management needs to be improved. Everybody is only talking about supply side. Now, you actually describe Justice Chandrachud as an idea man. And I would really work on that. Really, nobody is really thinking about on the demand side. I think Mahesh just mentioned that at the Supreme Court, the disposal of case is more than the filing. I think the backlog can only be changed by that. The disposal has to be much less than much more than what we are filing. And for that, you need an idea man. Because really, if you look at our 1863 Contract Act is largely outdated. What it does is it leads to frivolous litigation in India and waste everybody's time. Really, what is required, and I think that is something which this Justice Chandrachud should think about, is Section 73 of Indian Contract Act, which actually talks about damages, need to be significantly changed. If parties are intentionally breaching contract, they need to pay serious penalty, serious damages. I think that is something which Justice Chandrachud needs to think about, and maybe that is an area where we need to think about what we need to do. Same thing as with Section 74, that even if in a contract there's a liquid damages there, the courts have to see whether actually the suffering is as much as the liquid damages. The other thing is about the award. The interest should be actually as a right on award if there is a delay, and the interest should be the cost of capital for the corporate, because if he's using capital, then he should be paying that much of money. And these are very significant issues in my view, only, and if this can change, I would say the frivolous litigation in India can dramatically come down. And this is the best way to solve our pendency. And these are things where the parliament, the judiciary, the executive, and everybody has to work together. And one of the papers which we submitted to the Prime Minister in 2019 on the judicial reform paper for FICCI, on behalf of FICCI, this was very important that on economic policies, the government should work very closely, not on the fundamental rights, civil rights, but on the economic policies. The government and the judiciary should work together. Because if there is a policy, remember there was a policy by RBI on asset classification. And after 2-3 years later, the RBI said it is null and void. And it wasted so much of time. On economic policies, when the trickle down of benefits of economic policies go down to the last man on the street, I think these are the policies where the government and the judiciary needs to work together. And I think that is something, again, an idea man can do it, which basically help the country to move to the next level.
Point very well taken. Thank you for that closing comment. I'll go to Mahesh Agarwal, Managing Partner of Agarwal Law Associates.
Yeah, I think with so much investment that has been done on making e-courts and VC hearings, another way to reduce pendency will be to utilize vacations effectively. If hybrid hearings or VC hearings are permitted and encouraged during vacations, the judge can be on a vacation somewhere, the lawyer can be on a vacation somewhere else, but a hearing can take place virtually, as was happening in COVID. Now, normally what happens is in vacation, many cases are listed and just adjourned because either the lawyer is not there, the client is not there, something happens. So this virtual mode can be effectively utilized in Supreme Court and all other courts to list matters during vacation and dispose them off. Now, one way could be that there are many cases. Normally, in every case, one side wants a delay, one wants an early hearing. But there are many cases where both sides want an early hearing. Supposing you have a dispute with the state government. State government wants to know where this stand. The party wants to know. So a joint request can be made and matters can be heard during vacation very effectively. The VC system can be then utilized and pendency can substantially go down with that. Second thing is that what is now happening is that a list is already issued with a list of matters which have to be listed during vacation, and an option is given. Probably from that only a list can be made of what matters can be listed, what cannot be listed. That will effectively reduce a lot of pendency. One suggestion I wanted to give, which Dr. Singhvi will not like, is that one view is to encourage the bar. Many Chief Justices in the past have encouraged mentionings but not permitted seniors. Today, you have 100 matters where 25 seniors are appearing. The one way is to, what happens in a mentioning? List the matter early, list the matter delay, do this, do that. Junior bar can be very simply encouraged by saying that seniors are not allowed to mention. That will go a long way. It has happened in the past and it helped a lot of lawyers to open up in the court. That's a two-sided issue.
Thanks for the interesting points that you made. I'll go to Dr. Singhvi. If you could speak on Justice Chandrachud, the judge and the person, but also because this mentioning issue is brought about, and Justice Chandrachud made a comment on judges should hear matters now virtually because COVID cases are rising. I want to ask you one thing. You personally practice in the Supreme Court of India, but you also happen to go once in a while to the Delhi High Court, but many times to NCLAT. Why should you, if it is not an essential, go to these forums, run from one office to the other when you can appear virtually? You can be in Supreme Court and appear in Delhi High Court. You can be in Supreme Court where you're principally there. And if it's a 5-minute, then you can appear. Could you reflect on that? Why is it essential for you to take your car, bear the Delhi traffic, go, unless it's a long 1 hour appearance that you have to make? If it is not a 1 hour, why should you do it?
Okay, Tarun, you asked many questions on this. Since we're winding up, let me make my 5-6 points covering all the points, including your question and Mahesh's last comment about mentioning. First and foremost, let me say that the Chief Justice of India also is successful because he has the intellectual equipment. You need the intellectual equipment to be able to manage this. And I think there he also shines. I mean, look at the elegance of language he's able to employ. These are things which might sound small, but these are important things in judgment writing, in being the leader of the judiciary. You know, he's made these nice comments, not only in his speeches, but in judgments about dissent being the safety valve of democracy. encapsulating the whole issue. The very nice comment he made that, it's very difficult, but I try as a judge not to be judgmental of others. I have to judge them, but not be judgmental. Now, these are nuances of language, which ultimately are the tools of the trade for us on this side and for them on that side. Second, I think a lot of his tests are now in the offing. I've had the privilege in the last 2-3 months of arguing all these 4 cases where judgments are reserved. And he's had a continuous session of constitutional benches from Tuesdays to Thursdays. There is the NCT 2, which will definitively this way or that way deal with the equation and equilibrium between the Lieutenant Governor, the central government, and the NCT government. There is the Shinde Maharashtra judgment. There is the Cox and Kings, which we reserved yesterday. The arbitration matter, where arbitration group concept, very important for commercial law, where I did the rejoinder yesterday. And there is, of course, quick on the heels starting next week, which is why I said there's been a continuity of constitutional benches, the same-sex marriage issue, where I am likely to be the first or the second counsel. So we're preparing for that. So these are tests for the Chief Justice. He's in all of these, reserved or not reserved, and he will be then displaying his acumen and his talent in this. The third point I want to sound a note of caution. Arrears are the major bugbear of Indian law. But, we have been talking again and again in this program of arrears in the Supreme Court. Let me tell you, at the highest, the arrears here have been 1.5 lakhs. Effectively, they are less than 50,000 because of tagging. This is not even worth talking about, according to me, because the Supreme Court is an island of excellence and exception in a sea of problems. India has increased its arrears from the staggering figure of 3 crores pre-COVID to 4.25 to 4.3 crores post-COVID. That's the problem which he has to address. And that problem is not easy to address because he can only exhort, he can only, inspire the lower courts, but he has to provide that whole system because that's where the arrears problem has to be attacked at the base. Of these 4.5 crores, 4.25 crores, more than about 2.5-3 crores is right at the bottom. In fact, more than 3 crores. Less than 1 crore is in all the high courts put together. That's really, really something which is despairing and dismal. And it makes the entire Indian judiciary, for all the newfangled ideas you're talking about, all the technology and innovation you're talking about, it has to make your heads hang in shame. Then the last 2 points are that, this thing happens like a fashion once in a while. Every summer, every vacation court, every 1 or 2 years, individual benches say, oh, Dr. Singhvi, why are you appearing? Let's have only juniors for mentioning. And I always tell them this, which is the answer to Mahesh. I say, I am the first to say seniors should not be permitted, but you don't have a uniform rule. The problem is it can't be court-centric or judge-dependent. You must have a uniform rule. You'll be surprised that it is being done once or twice, but for very short periods. Today, Chief Justice Chandrachud has 100 plus normal mentionings. And as it is, it's a great boost to the younger bar because 70% of these are non-seniors, if not 80%. But there should be a ban. I agree entirely. And I'd be the first to hold it, but it has to be uniform. It can't be that some judges allow seniors, some don't allow seniors. That's the problem. And lastly, I think he is somebody who I think has a vision and a sense of legacy and a sense of a longer term continuity. I think that makes a lot of difference for a person because, you tend to correct self-correction and your self-correcting ways happen because you have a sense of how history will look at you. And I think that is important. That is a tempering influence. And as long as he continues with that sense of, how historically he will go down in history as a major Chief Justice, will make him do the right thing over a long period of time.
Thank you for so beautifully explaining all the points that you've made on the administrative side, on the judicial side, on the judge and the person, on the innovations, all of which we spoke about today. It was a very interesting 2-part series to have all 3 of you on the show, Dr. Abhishek Singhvi, Mahesh Agarwal, Managing Partner of Agarwal Law Associates, Mohit Saraf, Managing Partner of Saraf and Partners. I enjoyed interviewing you, but I have a caveat. I would require your presence and request your time once again when Justice Chandrachud completes 250 days in office, which means 3 more months There is enough and more time. And knowing Justice Chandrachud, I know there'll be enough and more to discuss. That's it for now. Thank you so very much for joining me.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.